Hello everyone, welcome back to RR Corporates. We have two channels, RR Corporates and RR Legal Talks. Now we are going to discuss a very important circular from Enforcement Directorate. On 20th June 2025, the ED, Enforcement Directorate, issued a landmark circular 3 of 2025, changing the way advocates are dealt with the enforcement investigations. This circular prohibits the issuance of summons to advocates without prior approval of the Directorate ED. The circular reinforces the legal privilege under Section 132 of the Bharatiya Sakshya Adhiniyam 2023. The circular shields advocate-client communications from compelled disclosure. This move comes after recent controversies where senior advocates like Pratap, Venugopal and Arvind Datar were summoned for professional advice given in legal capacity. So the key legal takeaways here is Section 132 of Bharatiya Sakshya Adhiniyam 2023 is talks about the advocate-client privilege. There are two exceptions, only two exceptions: the advice for illegal purpose or advocate knowingly assists illegality. These two are the exceptions. ED must now seek prior director level approval before summoning any advocate under these exceptions. This is the takeaway with this circular. So the ED's press release also withdrew the summons to senior advocate Venugopal and confirmed any queries would be addressed only in the capacity as a director, not as a legal counsel. So after this presentation, I will take you to the website of Enforcement Directorate and I will explain that circular and press release. And here the disclaimer is this video is intended for general awareness and commentary. Does not constitute any legal advice or opinion. So please consult a qualified legal professional for guidance on specific matters. Now I will stop here and take you to the official website. Now we'll go to the website of Enforcement Directorate. Then I will show you the press release also and circular also. This is the press release of press release. This is on Enforcement Directorate website. Here. This is Directorate of Enforcement, Department of Revenue, Ministry of Finance, Government of India. Here, if you see the press release, ED issued a circular for the guidance of the field formations that no summons shall be issued to any advocate in violation of Section 132 of Bharatiya Sakshya Adhiniyam 2023. Further, if any summons needs to be issued under exceptions carved out in the provision of Section 132 of the BSA 2023, the same shall be issued only with the prior approval of the Director ED. This is what it says. Just I'll click. Here, this is the press release. The Directorate of Enforcement ED, Mumbai, in which it has been alleged that shares of Care Health Insurance CHIL, Care Health Insurance Limited, were issued at a much lower price in the form of ESOPs, employee stock options, on 1st May 2022. This is the background of the case. In spite of a rejection of the same by Insurance Regulatory and Development Authority of India, IRDAI, as a part of investigation, a summons was issued to Sri Pratap Venugopal, an independent director of CHIL, to understand the circumstances under which the company has issued the ESOPs. Despite its rejection by IRDAI and subsequent to discussions in the board of CHIL, that is Care Health Insurance Limited, in this regard. So it is also pertinent to note that IRDAI on 23/7/2024 has directed the CHIN to revoke or cancel any ESOPs that have yet to be allotted, and has also imposed a penalty of ₹1 crore on Care Health Insurance Limited for non-compliance with the regulatory directions. So, in view of the fact that Sri Pratap Venugopal is a senior advocate in the Honorable Supreme Court, the summons issued to him has been withdrawn, the same has been communicated to him. So, in the said communication, it is also been stated that if any documents will be required from him in the capacity as an independent director of the CHIN, the same will be requested from him to be submitted by email. So, further, ED has also issued a circular for guidance of the field formations that no summons shall be issued to any advocate in violation of section 132 of the Bharatiya Sakshya Adhiniyam 2023. Further, if any summons needs to be issued under exceptions carved out in proviso to section 132 of BSA 2023, the same shall be issued only with the prior approval of the director ED. This is what the press release. This is the press release. Then I take you to the circular also. We'll go to the circular. I'll explain you for better clarity. This is the Directorate of Enforcement, Government of India. Circular dated 20th June 2025. Technical circular number 3 of 2025. Subject: Directive for issuing summons to legal practitioners, advocates, lawyers. It has come to the notice that field some formations are issuing summons to legal practitioners, advocates, and lawyers during the course of money laundering investigation to disclose or produce communications and documents in professional capacity pertaining to their clients. So, in this connection, attention is invited to section 132 of the BSA 2023, which is reproduced as under. So, 132 subsection 1, no advocates shall at any time be permitted unless with his client's express consent to disclose any communication made to him in the course and for the purpose of his service as such advocate by or on behalf of his clients, or to state the contents or conditions of any document with which he has become acquainted in the course and for the purpose of his professional service, or to disclose any advice given by him to his client in the course and for the purpose of such service. There is a proviso, provided that nothing in this section shall protect from disclosure of any such communication made in furtherance of any legal purpose. And another proviso, any fact observed by any advocate in the course of his service as such, showing that any crime or fraud has been committed since the commencement of his service. So these two are exceptions, proviso to subsection 1 of section 132. It is immaterial, subsection 2, it is immaterial whether the attention of such advocate referred to in the proviso to subsection 1 was or was not directed to such fact by or on behalf of his client. Explanation: the obligation stated in this section continues after the professional service has ceased. So, a client says to be an advocate, I have committed forgery and I wish you to defend me. As the defense of a man known to be guilty is not a criminal purpose. So, this communication is protected from disclosure. Another case, a client says to be an advocate, I wish to obtain a possession of property by use of a forged deed on which I request you to sue. This communication being made in furtherance of the criminal purpose is not protected from the disclosure. So the provisions of this section shall apply to interpreters and the clerks or employees of advocates. These are the subsections, section 132. So from the above, it is amply clear that the legal practitioners cannot be compelled to disclose any communication made to him in the course and for the purpose of his professional service as such legal practitioner by or on behalf of his client unless with his client's express consent. However, proviso to 132, section 132 of the BSA 2023 has carved out certain exceptions. In view of the above, it is directed that no summons shall be issued to any advocate in violation of section 132 of BSA 2023. Further, if any summons needs to be issued under exceptions carved out in section 132 of the BSA 2023, the same shall be issued with the prior approval of the director ED. This is what the circular. So this issues with the approval of the director, Directorate Enforcement. This is what the circular from the Enforcement Directorate of Enforcement Government of India. Hope we are clear. Thank you. Please do subscribe. RR Corporates and RR Legal Talks. We have two channels, RR Corporates and RR Legal Talks. Thank you.